Let's hope that worked. There we go. So, we are going to talk today about Lanita Tate. We've got the findings of fact here, and we're going to discuss. We got the decision. We're going to do it in two parts: findings of fact, the decision part, the sort of the narrative and the judge's explanation of her thinking. Second, we have. Yeah, so we're going to go through that. If you remember this case, she is a engineer. She makes an FMLA complaint. She leaves out of fear of retaliation, files with the ERD. That case is resolved. She then tries to get a job as a food service worker because she sees an ad that they're desperate for food service workers, thinks that'll be interesting, applies for the job, and is effectively blacklisted, even though they're desperate for workers because she's got issues. So let's see how that one plays out. Why, hello there. Okay. So there we can all see it together now. We've got our findings of fact. And here's the case. The respondent, the Milwaukee Board of School Directors, is an employer. It's not MPS. They'll trick you with that one. The Milwaukee Board of School Directors is an employer within the meaning of the statute. That's the one that's recovered by the Fair Employment Act here in Wisconsin, which is, yeah. The respondent operates Milwaukee Public Schools. The complainant, Lanita Tate, is an individual and employee of the respondent within the meaning of the statute. So she's covered by the statute, no question. As the question is the act illegal? The complainant began employment with the respondent in March of '91. The complainant worked for the respondent until 2021 when she voluntarily retired from her employment with the respondent. I mean, I don't know why she threw the word voluntary in there. I don't know why she put that in there because certainly the testimony was that she didn't really want to, but she was afraid of retaliation. But that was the word that she chose to use. The complainant began her employment with the respondent as a building service helper. The complainant was promoted to different employment positions during her time when she worked for when employment ended with respondent. She was a school engineer 1. Okay. And 19, the complainant worked at Starnes Discovery School in Milwaukee. The complainant's supervisor at Starnes was Kenneth McIntyre, buildings operations supervisor. I don't know why this is helpful, but okay, Judge, thank you. In 19, the complainant met with Brian Terry, the principal for Starnes, and Carrie Ludwig, the building manager for MPS. They discussed Ms. Ludwig's authorization and assignment of individuals to clean the school before the start of the year. During the meeting, the complainant informed Mr. Terry and Ms. Ludwig that she would be filing a complaint about Ms. Ludwig's neglect in sending staff to assist the complainant in the cleaning the building. Yes, I can say this because there's been testimony in another case about that, Kenneth McIntyre reported. Carrie Ludwig is now a worker. She's just an engineer now. She's no longer a supervisor because Kenneth McIntyre reported her for nepotism. I think her daughter got a very favorable position. Miss Ludwig did, according to the testimony that I understood from Mr. McIntyre. And then as a result of that, Mr. McIntyre was accused of stealing something from MPS and had to fight those charges. That's my understanding and recollection of the testimony. I could be wrong there. Okay. During the meeting, the complainant informed Mr. Terry and Ms. Ludwig that she would be filing a complaint about Ms. Ludwig's neglect in sending staff to assist the complainant in cleaning the office. The complainant used family and medical leave to care for her mother. When she returned from leave, the complainant was issued discipline for failing to complete summer projects, cleaning at Starnes during the 8-week summer session, and for failing to do mandatory building checks. That's while she was off on FMLA. On October 8th, 2019, the disciplinary meeting was held regarding the complainant's workplace behavior. The complainant was accused of violating portions of the MPS employee handbook regarding employee rules of conduct by threatening, harassing, intimidating, fearing, coercing with, oh my God, and using towards students, board employees, of the public. The complainant was also accused of building operation work rules by not demonstrating courtesy and rendering assistance to members of the public and other employees. This is one of those catch-all ones where they say that you are being rude to somebody. Okay, the complainant was accused of insubordination or poor customer service. This was considered a second offense violation. It's a lot of adjectives she could have put in there. Like voluntary, for example. The disciplinary meeting also addressed the allegations that the complainant exhibited poor performance in overseeing project cleaning during the summer intersession. Does she really say summer She does. The complainant was alleged not to have completed weekend building checks. This was considered a second offense violation. The complainant denied work rules, violating and rules of conduct. The complainant argued that any discipline for poor performance was not justified because she had been on vacation for 1 week and there were staffing shortages. She had also been on FMLA, preventing her from adequately completing her job duties. The complainant also argued that she was on leave when the building checks were not completed. FMLA leave. That's an important omission there. One is protected by law, the other is just her being out. After considering the evidence offered at the hearing, Kenneth McIntyre recommended that the complainant be issued a 5-day suspension for violating the handbook. Mr. McIntyre recommended that the complainant be suspended for 5 days, oh my God, and transferred to the Burdick School for exhibiting poor performance regarding the summer cleaning project and the weekend building checks. I think all this could have been said in about 2 sentences. The complainant grieved the discipline she received following the disciplinary hearing. Well, do we get a list of why she grieved it? No. Okay. Following the grievance process, Gilmore, employee race. Hey, Lisa Gilmore's an attorney now. I know her. Well, that's great. She's awesome, by the way. She's awesome. I mean, that makes a lot of sense. Well, good for her. So back in 2019, she was, I wonder if she got, we'll have to check her out. We could do that. All right, so we're going to go to Wisbar Lawyer Search. Bam. I will allow everything. First name, Lisa. Last name, Gilmore. She works for the city attorney's office. Bam, Lisa Ann Gilmore. Awesome. She went to Marquette. Ah. Well, that's interesting. That's what I recall from when I saw. Anyway, so she has been an attorney, but she wasn't working for the city attorney's. She's now working for the city attorney's office. Don't anybody mess with her. She's awesome. And not only that, they will wreck you if you do anything impolite to a city attorney. So please don't. And you shouldn't. But, okay. So that's interesting. She went to the same law school I did, and she went there before I did. That's what I recall. 1996 was quite some time ago. What she's doing as an employment relations specialist 3, I don't know. There are plenty of attorneys who work for MPS and other roles. And so that, who knows, but it's interesting to me now that she works for the city attorney's office representing MPS. But that makes a lot of sense. So thank you for helping me square that circle. Decided for Miss Gilmore also decided that the references in the discipline to being a second should be removed. Miss Gilmore noted, notwithstanding staffing shortages and the complainant's 1-week vacation, it was found that the complainant's, significantly failed. However, the complainant's prior disciplines were remote in time, so it was determined that considering the discipline as a second offense was an error. Okay. Something I'm seeing here is, again, when an employer says it, there's 2 paragraphs, and an employee says something, there's a sentence. I'm noticing a trend here. Following the grievance process, Employment Relations Specialist 3 decided that the 5-day suspension, and these are just HR flunkies. I mean, they're functionaries, flunkies, we call them factotums. I mean, Their point here is to check boxes and place layers between them, the public, and higher up bureaucrats. So they changed it to a 3-day suspension. Here again, they found, because there was evidence that the complainant engaged in unprofessional conduct that significantly impacted the work environment, but there was no evidence of relevant prior discipline, so that more severe discipline for a second offense was not warranted. Oh, look at here again. Complainant filed a second step grievance regarding the discipline she was issued. That grievance remains unsolved. Wow. So we're going to unpack that there. So now, first of all, you see how there's 6 lines there about what the employer says, and there's 1 line about what the employee says, and it doesn't say that the employee says that this is a bunch of bullshit. It doesn't say that at all. Then it also says that the grievance remains unsolved. Well, so what really happened is Ms. Tate paid like $900 to them to have this hearing, and then, of course, they just never scheduled the hearing and has never done anything to resolve any of these issues, and she remains not having been paid 5 days and having paid them $900 for the privilege of them having, I guess, taken their money and not done anything and laughed at her for, 3 years now. So that's great. Almost 4, going on 4. So that you don't, I'm just saying all of that was in the record. And so it's a choice by this judge to say that grievance remains unsolved. And that's what she's doing. So now you know what the actual story is. You can go look on the testimony there, see it for yourself. The complainant did not serve the suspensions before employment. Okay, well, that makes sense then. But she is out the $900. In 2020, the complainant of discrimination complaint with the ERD. All right. During her... Oh, my God. On what bounds? It doesn't say. God. All right. The complainant filed an internal complaint with MPS regarding the treatment she experienced with Ludwig and others. They filed her complaint on July 26th of 2019. She alleged that she was being treated differently than a school engineer with which she worked. Because of race, because of sex, because of nationality. On what basis, Judge? You got to know that that's in the form and that you can't file a complaint without alleging differently? That's a word choice. She alleged that she was discriminated against. We can go over that complaint ad nauseum, but that's the word. It doesn't say indicate how you were being treated differently. The law doesn't say that it's illegal to treat people differently. The complainant also alleged she was being harassed. For what reason? Jeez. After being filed, the complainant filed an internal complaint with the Employment Relations Department regarding the discipline she received. The complainant argued that the charges should not have been filed against her because she was on leave during the time mandatory building checks were not completed. The complainant believed the charges were filed against her because she filed an internal complaint with the Employment Relations Department against Carrie Ludwig and other supervisors. In October of 19, another employment relations specialist informed the complainant that the incident report she received for failing to do mandatory building checks while she was on FMLA would be removed from her file. Okay, MPS have at least 2 personnel files. We did learn that. One is kept by the department for which they work, and one is kept by MPS Employment Relations Department. When an employee requests a copy of their personnel file, they are provided a copy of the file maintained by the MPS Employee Relations Department. If an employee wanted a copy of the file maintained by the department, then the employee needed to request that file directly from the department. That's shocking that she puts that sentence in there. Because the truth is that they don't tell you that, and we only found that out in this hearing. And they admitted that they don't tell you that, and nobody even knows any of these facts. And then she doesn't put that in there at all. She just says if an employee wanted a copy of the file. It's a choice to leave out these countervailing facts. Choice. That's what a judge does, is they choose. They pick and choose which facts are winners and which facts are losers. But right here, what she's trying to do is say, this is what they said, this is what they said. And when the employer says one thing, again, it's voluminous, and Miss Tate is a piece of crap because, and then when Miss Tate says something, it's just that she complained. No details. And believe me, there's plenty of details. Therese Freiberg, then the manager of the ERAD, oversaw the investigation. Ms. Freiberg informed the complainant that investigation of her complaint had been completed. There was no finding of bullying by Carrie Ludwig towards the complainant. There was no finding that Ms. Ludwig treated the complainant any differently than any other school engineer. However, there was a finding that Ms. Ludwig probably retaliated against the complainant after Ms. Ludwig learned that the complainant had filed a complaint against her. Oh, okay. A copy of the letter from Ms. Freiberg was included in the complainant's personnel file maintained by the MPS Employment Relations Department. Well, that's good to know. Attorney William Wetzel of the Cross Law Firm, mailed a letter to Dr. Keith Posley, superintendent for Milwaukee Public Schools, about the complainant's workplace experience. Attorney Wetzel stated that they believe that the complainants experienced discrimination and harassment from her supervisors and at building operations based on her race and her opposition to discrimination in the workplace. A copy of the letter was included in the complainant's personnel file maintained by the MPS Employment Relations Department. On December of 2019, the complainant reviewed her personnel file maintained by Building Ops. The complainant saw in her personnel file documents related to insubordination, poor work performance, excessive absenteeism, and poor customer service. The complainant also observed letters from subordinates that she previously disciplined. Okay, the complainant noticed that there were disciplinary documents in the file maintained by Building Ops that related to allegations made against her work performance. Those disciplinary documents had been amended through the grievance process. The documents were to be removed, but remained in the file. The complainant asked that the documents be removed from her personnel file. The documents were removed from the complainant's personnel file. I don't recall that fact. I don't recall that they were removed. The complainant retired from her employment with the respondent effective January 1st. Oh, was it voluntary, or why did she do that? Prior to leaving, the complainant communicated with the manager in nutrition services, that's the kitchen, about returning and working in the kitchen. After retirement, the manager explained to the complainant the hiring process for food service assistants. Food service assistants perform a variety of general food production services, okay, including collecting money for food sales, washing dishes, cleaning the kitchen. I mean, maybe she could have used that time to explain to us what the complainant had complained about. In the summer, MPS sought individuals to work as food service assistants. There were approximately 150 food service positions available at that time. In June of 21, the complainant sought employment with MPS as a food service assistant. The complainant applied for the position online. When individuals applied for employment, MPS checked whether the applicants previously worked for the respondents to determine whether the applicants were eligible for rehire. Okay. I mean, possibly not. Possibly it's to discriminate against them. When individuals applied for employment, okay, Laquita Hoskin, talent management specialist, listed the respondents' electronic employment software, PeopleSoft, to determine if the applicants for food service assistant positions were previously employed by the respondents. See, this is bullshit right here, what she's going to say. Ms. Hoskins did not review the complainant's personnel files maintained by the MPS Employment Relations Department or the Building Ops to review the complainant's employment history with MPS, but she did review PeopleSoft, which has the documents in there. Because the complainant met the minimum qualifications, including being eligible for rehire, the complainant was invited to take the required civil service examination. So they don't dispute that she looked. Okay. On July 21st of 2021, the complainant learned that she was to take a written civil service exam. The complainant appeared and took the civil service exam. Ms. Hoskins reviewed the civil service exam results for the applicants. It was determined that the complainant scored 96 and achieved a ranking of 2. The complainant was informed that she would be contacted by the Department of School Nutrition to schedule an interview. There were one individual ranked 1 and 4 others that ranked 2. Okay, and there was 150 positions. MPS used the civil exhibit to determine the individuals to interview. When the civil service examination scores were not combined with the applicant's interview scores to determine which applicants to hire. Only the interview results were used to determine which applicants to hire. Well, that's total bullshit, and you know it, because there's a whole matrix that we have here of them discussing what qualifications people had. Also, that they had been on FMLA, that they had made complaints against MPS, and other things like that. So no, Judge, you can't say that. I mean, that's a choice right there. That fact does not conform with the evidence. Around 4 p.m., the complainant spoke to Renee Slotin, Beauchamp, operations manager for nutrition services for MPS, about scheduling an interview. Thanks for letting us know that. The complainant received an email saying was not selected for the position. Okay. 4 minutes after receiving the email, that sounds kind of suspicious that 25 minutes after applying, she was told that she didn't get the position. 4 minutes after receiving the email, she called and they said, oh, it was a mistake. Was scheduled with her at 11. Okay. At 3:43. Hoskins emailed the complainant informing her that they mistakenly emailed and messaged her that another applicant had been hired and that the complainant was no longer being considered for the position. Ms. Hoskins advised the complainant to move forward with the process. The complainant that MPS was still interested in her being part of the team. So the complainant interviewed with her on the 21st, August 19th, 2021 at 11 a.m. Aren't you glad you know that? All right. All applicants were asked the same question. See, that's not true. She says that she tried to do that, but the testimony doesn't support that statement. During the interview, the complainant discussed her previous employment with MPS as a school engineer. The complainant explained that she worked for MPS for 35 years, that she had worked in maintenance, had retired, and needed something to do. The complainant mentioned that she was employed by MPS. She helped out on the kitchen staff. The complainant informed her that she wanted to work behind the scenes at a central kitchen, not to have contact with children, and she didn't want to be in charge. Okay, so it sounds like a worker. Okay. They needed 150 of them. She was comfortable receiving direction. As an example, the complainant explained that when she was a school engineer, she did not want to change the way she did summer cleaning, but she was shown a new way and determined that it worked. Wow. The complainant also discussed how she handled high-pressure situations. During the interview, the complainant was questioned about her need to take time off in the past year because of illness or some other reason. That she had been retired, she used most of her sick leave to take care of her mother. Miss Slotin Beauchamp sympathized with the complainant because Miss Slotin Beauchamp took care of her mother before her mother passed away. Well, thank you so much for letting us know that. Okay. Complainant didn't have any experience with the computers. Complainant informed Slotin, but she communicated with Christina Rothy about working in the kitchens, and that Miss Rothy told that complainant that she would hire her. Well, so that's good. The person who would be her supervisor saying that they would hire her. Okay, that sounds pretty good. Finally, that she wanted to work in the school for about 5.5, 6 hours a day to restore sick hours so she would be eligible to receive medical insurance during her retirement. Well, that sounds like a great thing. Oh, well, that's too bad for her that she didn't get it hired by MPS, only by the temp agency. Medical insurance would have been nice, wouldn't it have? Too bad for her she didn't get it. The complainant didn't know Slotin Beauchamp regarding an interview process. She got a 3 out of 1 to 5. The complainant was marked do not hire. Okay. Did not communicate with Carrie Ludwig about the complainant. Ms. Lambert was concerned with the complainant's comments during the interview that she was bored. Okay. Ms. Slotin Beauchamp did not review the complainant's personnel files maintained by MPS. I'd say maybe that's true, but Christina Rothy, dietitian, provided Ms. Hoskins with the names of individuals that apartment supervisors wanted to hire. The complainant was not selected. In the paperwork Ms. Rothy provided was the names of individuals that the nutrition wanted to hire. It was noted that the complainant made it very known that she was just bored. It was also noted that the complainant was a former facilities worker who had issues. So we went through the testimony with Ms. Slotin Beauchamp, and she couldn't show us anywhere in her statement, anywhere that recommended. She didn't know because she didn't look at the personnel file. She didn't know about any issues. But somehow when it goes from Christina Rothy to the HR, it says she has issues, a former employee who had issues. Okay? So either Slotin Beauchamp put that in there or somebody else put it in there based on her file. But it's the had issues part that's the problem. Especially, let's also put in there, on this document, it says that other people had taken too much FMLA. I mean, that's just illegal. Nowhere, that's not mentioned in there at all, but okay. And to my mind, that comment right there, a former facilities worker who had issues, is the whole case. Okay, issues, in my mind, is that she filed complaints. Notified the individuals who were accepted for hire, notified that they were not selected for hire food service assistants. The complainant learned that the respondent would not hire her. Through email communications, the complainant asked Ms. Hoskins about the reasons she wasn't hired. Ms. Hoskins informed the complainant that the decision not to hire was based on her interview results and a review of her file from when she was an employee. Bam, smoking gun right there. The complainant questioned Ms. Hoskins what was in her file, noting that the last time she checked her file was in good standing. Ms. Hoskins responded that she was not provided specific information, and that was all that was provided was her interview notes, meaning former employee who had issues. Okay, so that's the link there between that statement, former employee who had issues, and the interview notes, or the file. Who wrote the interview notes? Because the person she received the interview from that she did well during the interview, that she did not have any information more to provide. That's what Ms. Hoskins said. Ms. Hoskins did not review the complainant's personnel file maintained by the MPS to respond to the complainant's email communications, right? She didn't need to because it says here that the decision not to hire the complainant was based on her interview results and a review of her file from when she was an employee. Bam. So she didn't have to do it then, because either she did or somebody else did and communicated to her. How else would Ms. Hoskins know about that? Hoskins told her that she got a 3 out of 5. They reviewed her personnel files. Okay, there it is again. Did not communicate with Ms. Rothy about the reasons that the complainant was not being hired for the food service assistant position. Sometime Ms. Hoskins talked to her manager about the decision not to hire the applicant when the applicant provides information to Ms. Hoskins to support their hire by MPS, but Ms. Hoskins did not communicate with the manager about the complainant's concern not being hired because the complainant did not provide Hoskins with reason why the complainant believed she should have been hired by MPS. See, that's garbage. What she even testified to was that she didn't give her specific enough ones. She just didn't feel, but that there was no way that even just reading what was said before, that it just says over there that Slotin Beauchamp told Tate that she had a good interview. So how's that? I mean, we've got absolutely contradictory statements here. Now, that's okay that this is just the judge was saying these are the facts, that it's okay that this fact said that if she says that Hoskins said that, that's fine. But if she says that it happened, that's a different story altogether. Okay, this is what Ms. Hoskins did not communicate. See, this is what the problem is. Ms. Hoskins did not communicate with the manager about not being hired for the food service assistant because the complainant did not provide Ms. Hoskins reason for why the complainant believed she would have been hired by MPS. So that if she had said Ms. Hoskins said that, fine, but she's saying that that's a fact. That's a problem. During her interview, the complainant did not inform that in Slot and Beauchamp that she filed a discrimination complaint. Okay. During the interview with MP, that she did file an internal complaint. Okay. But that's in her personnel file. During her interview, the complainant did not inform Ms. Slot and Beauchamp that she filed a grievance, right? It's in her personnel file. In September 21st, MPS decided to no longer interview. They just hired him. Okay. When she was not hired by MPS, the complainant sought employment with Talent Bridge and was hired anyway. And now she earns $15.50 an hour. Complainant earned less than $15 when she worked with Talent Bridge, and complainant works an as-needed basis at MPS. Okay. Jesus. Complainant reports to an MPS employee while she was working on MPS property. Complainant reports to an employee from Talent Bridge to report absences from work. The respondent did not refuse to hire or employ the respondent because the complainant opposed a discriminatory practice under the Wisconsin Fair Employment Act. The respondent did not refuse to hire or employ the complainant because the complainant made a complaint under the Wisconsin Fair Employment Act. Okay, so there you have it. Those are the findings of fact in the Lanita Tate case. Thank you very much, Judge Stephanie Brown. So we will have more to come. All right. Stick with us. I'm sure we'll keep you informed on this one. There's going to be a lot more Lanita Tate. I'll give you the second half of this decision, and then we're going straight into MPS. Yes, sir. Stick with us. We'll keep you informed.